Hello everyone, welcome to our channel Law School Simplified 256, where we make law simple and accessible. In this video, we are going to look at the types of contracts. However, for purposes of timely updates, I encourage you to subscribe, like, share, and also comment on our videos. As a student who has just joined law school, you must know the types of contracts. However, we should not ignore the definition of a contract. Therefore, we shall look at the definition of a contract and we shall proceed to look at the types of contracts. The definition of a contract is provided for under Section 9, subsection 1 of the Contracts Act, Cap 284, and it provides that a contract is an agreement made with free consent of parties with the capacity to contract for a lawful consideration with the lawful object and with the intention to be legally bound. That is the definition of a contract. The main purpose of contracts law is to enforce the agreements of parties. So, for there to be a contract, there must be an agreement. But don't ignore the fact that all contracts are agreements, but not all agreements are contracts. With that, let us proceed to look at the types of contracts. Contracts can be categorized into valid contracts, voidable contracts, void contracts, legal contracts, and unenforceable contracts. Let us proceed to look at one by one. Valid contracts. Valid contracts, these are contracts which are enforceable in courts of law. For a contract to be valid, it must contain all the elements of a valid contract. The elements of a valid contract can be found in the definition of a contract. And also, the elements of a valid contract were laid down in the case of Greenboat Entertainment versus City Council of Kampala, where Justice Bamwine held that for a contract to be legally enforceable, there must be capacity to contract, intention to contract, consensus ad idem, valuable consideration, legality of purpose, and sufficient certainty of terms. Those are the elements of a valid contract. So, if a contract lacks any of those elements, it is called something else, but not a contract. Let us look at void contracts. These are contracts which entirely lack the legal effect and are not enforceable from its inception. So, for a void contract, it is not enforced because it lacks a legal concept. This is because these contracts, they don't meet the basic requirements of a contract. So that's why they are called void contracts. Now, let us look at voidable contracts. Voidable contracts, these are contracts which are vitiated by either a mistake, misrepresentation, undue influence, or duress. So such contracts are void if the innocent party does not agree for them to proceed. When you look at an instance where you enter into a contract with someone who lacks the capacity to contract, this person can say that let us proceed with the contract, or can say that we should stop here, the contract should stop here. Therefore, once this innocent party says that the contract should stop here, then it is rendered void. Let us proceed to look at legal contracts. illegal contracts. In illegal contract, we see that this is an agreement or promise which by its nature is prohibited by law. So this is a promise that is prohibited by the law. The general rule is that courts cannot enforce illegal agreements or illegal contracts. In an instance where Peter promises to give John 40 millions if John pours acid on Patrick's face, John goes ahead to pour acid on Patrick's face, and John goes ahead to claim for the 40 millions from Peter. If Peter refuses, in this instance, this contract is not enforced under the courts of the law because courts cannot enforce illegal contracts. Thank you for watching Law School Simplified 256, where we make law simple and accessible. I encourage you to subscribe, like, share, and also comment on our videos. Let us meet in our next video. Thank you.